Thank you to everybody for joining us today. Thanks for joining the Center for Financial Security, as well as many of our guests that we have here to present. We are doing a webinar session, Information and Resources for Landlords, Tenants, and Homeowners during the COVID-19 crisis. My name is Hallie Leinhardt. I'm the Assistant Director of the Center for Financial Security here at the University of Wisconsin-Madison. And just to give everyone a bit of a rundown on our agenda today, we'll begin with a presentation by Legal Action Wisconsin, which will provide an overview of eviction rights for landlords and tenants. Next up, the Department of Agriculture, Trade, and Consumer Protection will discuss the eviction moratorium, as well as the emergency rule banning late rent fees. The Department of Administration will then provide an overview of Wisconsin Rental Assistance Program, or RAP. And finally, we will finish with a presentation by the Wisconsin Housing and Economic Development Authority, which will provide information on the Housing and Urban Development Moratorium and some related issues. We will then continue with a question and answer session, so please feel free to submit questions in the question chat box that's located at the right side of your screen throughout the webinar. Please note that the webinar is being recorded today. We will post the recording on our website with the slides within 2 business days, and all registrants will also receive a copy of that recording via email within about a day. I'm very excited to introduce our presenters for today's webinar. We have Jessica Roulette. She's an attorney with Legal Action of Wisconsin. Laura Sutherland is Administrator of the Division of Trade and Consumer Protection at the Department of Agriculture, Trade, and Consumer Protection. Susan Brown is Administrator of the Division of Energy, Housing, and Community Resources at the Department of Administration. And Bonnie Robertson is Senior Housing Management Officer at the Wisconsin Housing and Economic Development Authority. Thank you all for being here. And with that, we will get started, and I will turn it over to Jessica.
Good morning. I just wanted to say that we are recording this presentation, and I wanted to acknowledge that this is a difficult time for many people in our community and helping professionals, given what's going on in our neighbor state to the west. So if you need to look at this later, it will be posted later. The entire session will be recorded. So with that, I'm going to be talking about sort of the broad overview of how landlord-tenant law works in the state of Wisconsin. And the laws themselves have not changed, even due to COVID. How they are being administered, though, has been changed a bit. So, next. There are 3 sort of sets of statutes that I would refer to on specific questions. The first is Chapter 704 of the Wisconsin statutes that governs, or that lays out sort of Wisconsin law as it pertains to landlords and tenants. Then there's a separate Chapter 799 that addresses how small claims cases are handled. All of the civil procedure statutes, chapters 801 through 847, also apply to these court cases. And then the Department of Agriculture, Trade, and Consumer Protection has administrative rules in Chapter 134 that regulate trade practices in the landlord-tenant realm. And those should also be referred to. Next. Next slide. So, there are 3 basic types of tenancies in Wisconsin. In order to know who can do what to whom or for whom, you need to know what kind of tenancy you are in. The first is a tenancy under a lease. A lease lays out a set beginning and end date of the tenancy. So our example is Sharena agrees Mustafa can live in a unit from February 1st to April 30th, and it sets the rent as $500 due monthly. There's a periodic tenancy where rent is paid on a weekly or monthly basis, but there is no set end date for the tenancy. So, for example, Sharena agrees Mustafa can move in February 1st and pay $500 each month. You can also have these rentals on a week-to-week basis as well, but month-to-month is the most common in Wisconsin. And then there are tenancies at will, which is where the tenant is permitted to live there but has no lease and does not pay rent on a particular periodic basis. So our example is Lois tells her grandson he can move into her basement and live there for a while. He pays nothing. He is a tenant, and there are rules that apply to what happens if that relationship breaks down and grandma wants grandson out. Next slide. So in order to terminate a tenancy or end a tenant's right to live in the unit or house, a landlord must almost always provide a written notice. And in that written notice, the landlord has to say the reason that they are terminating the tenancy. Sometimes it can be because I want to. Sometimes it can be because you're late with your rent. Sometimes it can be because there have been, 15 police calls and it's a nuisance and I need to get you out. There are lots of reasons landlords give in their notices. And in some notices, the tenant is given an opportunity to fix or cure the problem. For example, if you are late with your rent, there's a cure period during which you have a set time period, 5 or 14 days usually, to get caught up on your rent. And if you fix the problem or cure the issue, then the tenancy is not terminated. If you fail to fix the problem or cure the issue, the tenancy is terminated at the end of that notice period. If you get a notice, and if you are a tenant and you get a notice and you want to know if the notice is correct and follows Wisconsin law, you can call legal action at the number listed in the slide to be assessed for whether you're eligible for assistance and then to get some legal advice or information or referrals. Next slide. Then the next step in the eviction process is court proceedings. So once a tenancy is terminated, so you get the notice period ends, whatever the problem was hasn't been fixed, either the tenant has moved out on their own or they have stayed past the end of their tenancy, and then the landlord's option is to begin a court proceeding. The landlord has to file documents called a summons and complaint. That summons and complaint has to comply with state law and local court rules. And once that summons and complaint is filed, it has to be served properly on the tenant. And then the summons and complaint will contain in it a hearing date, a first hearing date, which lawyers call a return date. And at that first hearing, depending upon what county you live in, you are either required to appear in person, which right now in many places is appear on Zoom. We'll get to that. File a written answer on or before that first hearing date, or in some counties you have to both file an answer and show up, whatever showing up looks like under COVID times. So we'll get to that. And again, the summons and complaint also has to follow certain rules and say certain things to be considered a valid basis for a court to enter an eviction judgment down the road. So if you have been through the notice, if the notice terminating your tenancy appeared to be valid, and now there's been a summons and complaint filed, and you want to know if that's valid, again, you can call legal action for assistance so we can determine whether or not the summons and complaint is correct and meets all the legal requirements, and then to also get advice about what your options are at that point in the matter. Next slide. So, yeah, courts across Wisconsin are addressing COVID-19 in different ways. The normal court procedures, I think, are not. So normally a court posts its local rules, which you can find on their websites, and the local court rules tell you how courts are handling matters, what specific things the court wants from you or wants you to do, or how it wants you to give it the court information. And those local rules are usually posted on their website. There have been a lot of emergency changes to prevent the transmission of the COVID-19 virus. And so some courts have their websites have the information on them. I think all courts in their notices, the official court notices that people are getting on their court cases, the courts are explaining in writing in their notices what procedures they're following. Is it going to be a Zoom hearing? Is it going to be a phone hearing? Do they want people to come in? If so, are there limits on who else can accompany the litigants, the people that are coming to court? So it would be impossible to list all of those procedures, and the procedures are changing fairly quickly. So our best advice is to read every notice you get carefully. And if you're confused or uncertain, go to your county court's website to look for up-to-date information. Many of them have a red banner across the top saying COVID-19 procedures in place, and you can link in then. If you do not have internet access or you do not speak or read English well enough to access that information, then you can also call the clerk of courts for your county to get answers to your questions. It's important to know what county your court case is in, because it is, again, being handled differently by different court systems, by different county courts. And you don't want to find out how Milwaukee's doing hearings if your hearing is in La Crosse, because it won't do you any good. So it's really important to know what county your court case is in and consult the appropriate court officials. We are at Legal Action doing our very best to keep up to date as to each county's in our service areas current procedures. And so if you can't get through or you can't access the information, you can, also again call Legal Action to be screened for eligibility and then to get information and advice about how your case is likely to go. Next slide. So I've been explaining how evictions are supposed to go, which is you're supposed to get a written notice, and then there's supposed to be a summons and complaint file. Sometimes tenants believe they are being evicted because locks have been changed or utility service has been cut off by the landlord at the property as a sort of informal shortcut way to just, force a tenant to move. That is not legal. I would say that it has become less common, but I do know that everybody is pretty frantic right now, even landlords. It's not just the tenants that are suffering financial harms during these times. It's everybody, right? So I just wanted to remind everybody that lockouts are illegal, and landlords are also not permitted to cut off utility service as an informal means of removing a tenant. However, the remedies that what the landlord can do to get a tenant out is serve the proper notice, file a proper court case, get a judgment of eviction, and then file a paper called a writ of assistance with the court that they then take to the local sheriff's office. And the sheriff then will go out to physically remove the tenant from the property. That is expensive and time-consuming, and nobody, including the tenant, wants that to happen. So that is really sort of the worst-case scenario, but that is the final means that a landlord has at their disposal to remove a tenant who simply won't go, even after a judgment of eviction. At any point in this process, of course, landlords and tenants are free to negotiate a different off-ramp from this process. They're free to come to an agreement and come to another way for the tenant to leave and the landlord to regain possession of their unit. But this is sort of the the worst case scenario is the landlord has taken every step, the tenant is still there. The landlord is then permitted to seek the assistance of the sheriff's office to physically remove the tenant. If a tenant has questions about the process, again, they can call Legal Action, and we will explain to them what options remain to them and what rights the landlord has to regain possession of the property once the court proceedings have gone to their natural conclusion. Next slide. So this slide is pretty self-explanatory, but the best information to provide to tenants is that they should pay some rent every month. We definitely hear at Legal Action, we hear of tenants who have concerns about the condition of their living units, and they consider refusing to pay rent or withholding rent. There are very specific rules and laws in Wisconsin that apply to rent withholding based on condition of the unit. Our usual and best advice is to pay your landlord something no matter what the condition of the property is. And to escrow or to put aside the remaining rent so that down the road it's available to pay. If you do that, you have a much better shot on a rent withholding issue. Again, also you don't have to go right to that. You can negotiate with your landlord You can try to consult an attorney at Legal Action or in another, at another local agency to try to get information about is the problem with the property appropriate for rent withholding? Are there other ways to get the living conditions improved, which really is the goal? And so just no matter what the situation is, it's always best to pay your landlord something every month. Next slide. So then this is really where many tenants find themselves. The best thing to do is to not have an eviction case filed at all. And the best way to prevent an eviction case from being filed, well, first of all, is to pay your rent when it's due. But there are many people right now, through no fault of their own, who are unable to do so. And so the best thing to do is to be proactive and just talk to your landlord if that's possible, if it's possible to communicate calmly and rationally about this, and try to reach some agreement about how and when past due rent will be paid. And it's really hard, especially for tenants who are in a position where they don't know when their income is going to resume, if it will resume, how it will resume. But even so what you can do is you can try to reach some sort of agreement based on what you think is going to happen. And, an agreement can always be revised or changed. So as circumstances change, agreements can change. So our advice is that tenants should really try their best to communicate with their landlord and come up with some sort of agreement, and then ask the landlord if they're willing to put in writing, like, we have agreed that, March and April's rent have not yet been paid, and maybe May's as well at this point, maybe even June. So it's 4 months now. We're talking that maybe or maybe it's April, May, and June probably, right? So that's 3 months of rent. And here's what we think we're going to do. We're going to say we're going to pay that back by the end of the lease. So, and then at the rate of such and such, depending on what you're at $50 a paycheck or $100 a paycheck or whatever you think is going to be a reasonable amount. And then, I don't think there's a single landlord anywhere. If you suddenly get a big back unemployment check because your unemployment finally got processed or whatever that holdup is for your income flow, that would object to having that back rent paid off earlier, but at least having a written agreement stating the tenant's intention and their best efforts helps the landlord then make plans of how they're going to manage their cash flow and their expenses that are coming due each month as well. Our Legal Action would hope that everybody will be as flexible and understanding as possible, and that landlords that have the capacity try their best to hold on and not evict tenants who have been good prior to this, because there are emergency funds coming, and it's our hope that if tenants can hold on at least until July to start getting some of this emergency money, landlords could be made whole, and people aren't going to be sort of unnecessarily shuffling around and trading tenants, and tenants can stay safe in their homes. So we're hoping that people are going to be able to communicate and reach agreements and reach understandings, memorialize them in writing, and just avoid the whole court system altogether as they work together to sort of find a way forward out of the mess we're all in. Next slide. So maybe this is good news. I have several slides here at the end now about where tenants who don't have money right now and owe overdue rent, where they can go for assistance to get money. The first big program, which has been in the news and is going to be covered in more detail later, is this program. It's got $25 million, up to $3,000 per household to eligible Wisconsin residents. It will help pay rent and security deposit expenses. It's being administered through community action programs. I have the website link. You can look up who your CAP is in your area. And also the other thing to know is that CAPs, these community action programs in different areas of the state have different funding sources and different abilities to help people pay rent above and beyond this RAP program. So it's always advisable if you're a tenant, when you're talking to your CAP, to find out your community action program, to find out if they have what other programs besides the new one might be able to help you as a tenant get the money you need to make your landlord whole on the back rent that's due. Dane County residents are also going to have special resources that are being made available to them to pay overdue rent that's come up since March of 2020. Those applications will be taken starting, I think, next week, starting in June. The funds, again, will be available in July. So if people can come up with a plan and come up with an agreement and hang on until the money starts to flow, hopefully people can stay where they are and stay safe in their homes. The Dane County funds are going to be administered through the Tenant Resource Center, and I've included their number on the slide. Next slide. Now, the next two sources on here are not rent specific. Well, they sort of are. So the first is the Unemployment Insurance Program has special funds available for Wisconsin residents who are unemployed between April and July of 2020. Residents can apply for unemployment assistance. We really recommend that they try their best to go through the website. I know not everybody has internet access and not everybody has a computer. There is a phone number, but as you can imagine, that department is really overwhelmed. And so if you're at all able to access the internet through a computer, going through the website is really your best option to make an application to try to get assessed for your eligibility for this unemployment money, which could, again, cash in your pocket to pay the rent. There's also a program that's always available regardless of COVID or not, which is called Emergency Assistance. That is available to low-income residents of the state who have minor children in their care. And Wisconsin residents apply for emergency assistance at their local W-2 agency. Again, that's different throughout the state, so I've included the link to how you find your W-2 agency to figure out how to apply. I think also that can all be done online right now while agencies are shut. As they reopen, there may be different requirements, so you want to read all your instructions carefully. And the legal action does help people who are having issues either getting qualified or understanding the application process or who have been denied for either of these programs. You can call legal action at our intake number to be assessed for whether we can help you with either getting your application processed or appealing any kind of denial. Next slide. So in all the counties other than Milwaukee, Dane, and Racine, the Wisconsin Rural Housing Assistance can offer limited assistance with unpaid rent. And I have included the link for that organization as well. For the counties of Milwaukee, Waukesha, Kenosha, Racine, Ozaukee, Washington, Dodge, Jefferson, and Walworth, Impact 211 can screen tenants for eligibility for rent resources. You call 211 on your phone, answer questions about who lives in your house and what your financial resources are, and Impact 211 can screen you to see what kind of programs are available and help route you to the applications for that. There is a special website called rentreliefdoorcounty.org for Door County residents to seek assistance paying overdue rent. Next slide. For the greater Milwaukee community, there is a helpline for landlords and tenants at the Rental Housing Resource Center, and I've included the phone number on the slide. And then finally, the Salvation Army and St. Vincent de Paul sometimes help in some counties of Wisconsin with some back rent. So this is the best list of resources that I've been able to find for people who need the money. The only problem is they've had no income and they are behind on their rent. And the last three or four slides of this presentation are our best list of current resources and where to get money to get to your landlord. So I hope that this has been helpful, and I appreciate your attention.
Thank you, Jessica, and thank you, everybody, for attending this webinar. My name is Laura Sutherland. I'm the administrator for the Division of Trade and Consumer Protection at DAGCAP, and I first want to thank the Center for Financial Security at the UW for hosting this important seminar during this time of crisis. We turned it around very quickly to get these resources out to people who need it. So we really appreciate you pulling it together. Thank you, Hallie, for that. So as we all know, these are unprecedented times, and we're hopeful that this webinar will clarify changes to the Wisconsin landlord-tenant regulations that have happened in light of the COVID-19 pandemic. But before we begin, I want to introduce you a little bit to the Bureau of Consumer Protection. Located within the Department of Agriculture, Trade, and Consumer Protection, we are the state's consumer protection agency. Our mission is to ensure fair business practices for both buyers and sellers alike by prohibiting fraud, deception, and unfair business practices in the marketplace. Consumer protection regulates landlord-tenant relations. We are responsible for the enforcement of the Wisconsin Administrative Code, Chapter ATCP 134, which governs landlord-tenant rental practices. And we have a resource guide for landlords and tenants that we encourage you to acquire from our website and other valuable information that you can find there. Next slide. So in response to the pandemic, there have been a number of temporary changes to landlord-tenant regulations. In late March, the governor issued an emergency order placing a moratorium on residential and commercial evictions for non-payment of rent. There's also been an emergency rule by our department related to residential rental late fees. So this brief presentation will provide more detailed information about these temporary changes. Next slide. Many tenants wondered if they could be evicted during the COVID-19 emergency. On Friday, March 27th of 2020, Emergency Order 15 was issued by the governor, placing a temporary suspension or moratorium on residential and commercial evictions for the non-payment of rent. The order did a couple of important things. First, landlords could not evict a tenant for 60 days, which ended on May 26th, this past Tuesday. During this time, no evictions could take place unless there was an imminent threat of physical harm. So, in absence of an imminent threat of physical harm, tenants could not be evicted for the non-payment of rent. This was true for residential and commercial properties. This order did not mean tenants should cease paying rent. The order ended at 8 a.m. on May 26th, this past Tuesday. So what does this mean? One important question that DADCAP has received is whether the eviction orders dated prior to March 27th can continue to be executed now that the moratorium has been lifted. The answer to that question is no. Under state law, no eviction order shall be executed if received by the sheriff more than 30 days after the court issued it. So any eviction order issued before March 27th, but not yet delivered to the sheriff, may not now be executed. Jessica talked a little bit about these writ of executions in her presentation. Likewise, any eviction order issued and delivered to the sheriff before March 27th may not be executed because the sheriff must execute those orders within 10 days of receipt. So the end result is, given that the eviction proceedings have been suspended for over 40 days since March 27th, the eviction orders dated prior to March 27th can no longer be enforced, as they can no longer be executed by a sheriff. However, starting on May 26th, eviction proceedings, including the following, could begin for some rental properties: the serving of a notice of terminating a rental agreement, including a lease. Jessica talked about those various types of tenancies. Commencing a civil action of eviction, or delivering the eviction notices to the sheriff. Evictions continue to be suspended from March 27th to July 25th for non-payment of rent by tenants at HUD multifamily assisted or FHA insured properties. And Bonnie Robertson of WIDA will discuss this in more detail later in the webinar. There's also HUD guidance related to COVID-19, and that can be found at the HUD's website as well as WIDA's. While many tenants are experiencing extreme economic hardship during these times, tenants should continue to pay rent if they can. And as Jessica has said, we encourage landlords and tenants alike to work together to identify how they can make rental payments during the crisis. And if there are temporary modifications that are made to the amount or timing of those rent payments, you should get those new agreements in writing. Next slide. On April 25th, the Department of Agriculture, Trade, and Consumer Protection published an emergency rule, Wisconsin Administrative Code ATCP 13409, subsection AD, governing fees related to late rent payments. This emergency rule took effect the same day, Saturday, April 25th. The emergency rule prohibits fees for non-payment or late payment of rent during the emergency order and the 90 days following the expiration of the governor's executive order number 72. The rule then will expire on August 8th, 2020. The department held a public hearing on this emergency rule on Thursday, May 21st. And we also accepted public comments in writing until the close of business on that same day, May 21st. Under the rule, late fees and penalties may not be assessed or charged for any missed payment or any late rent payment that occurred during April 25th through August 8th. The emergency rule does not apply to late fees and penalties charged prior to April 25th. The emergency rule only applies to late fees and penalties for residential rent. And the emergency rule does not change or waive rental payments due under the lease. Tenants are still required to pay their rent according to the lease. So again, we encourage landlords and tenants to work together, determine how best to get these rent payments made during the public health emergency, and any changes to that agreement should be reduced to writing. Tenants in need of financial resources may be eligible for the statewide rental assistance program. Jessica touched on that briefly, and Susan Brown of the Department of Administration will be talking about that next. This is a very important new resource. Landlords can also look to Wisconsin Economic Development Corporation for information on state and federal resources for small businesses affected by the crisis. Next slide. So Jessica did a really nice job of laying out all of the resources around the state available. And this is a brief description of some more places for folks to look. In addition to the statewide rental assistance program, which will be discussed next, we encourage tenants to look to their counties for assistance, as mentioned by legal action. Dane County has set aside $10 million for eviction prevention, for instance, and local assistance may also be made available through the Salvation Army and St. Vincent de Paul. Financial resources are also available for eligible landlords. The federally passed CARES Act provides protection for homeowners with mortgages that are federally or government-sponsored enterprise-backed or funded by FHA, the VA, the USDA, Fannie Mae, or Freddie Mac. And this is going to be covered by Bonnie Robinson of WIDA later in the webinar. The Consumer Financial Protection Bureau also has information on its website about mortgage forbearance and mortgage relief options that may be available for landlords. And again, landlords can go to the WEDIC website, Wisconsin Economic Development Corporation, for more information about state and federal resources for small businesses. Next slide. So should you have any concerns or questions or issues relating to your tenancy, you can file a complaint with our department and make an inquiry related to your landlord-tenant situation with our department. You should call our hotline at 1-800-422-7128. You can visit our website at datcp.wi.gov. We have more frequently asked questions on this topic and other information about COVID scams in general. We encourage you to contact us to report any COVID-related scam or fraud you may encounter. Even if you don't fall victim to it, notifying the department about this allows us to prosecute cases and investigate cases and also get out more information and education to prevent fraud in our community. And finally, we ask you to follow us on Twitter and Facebook for the latest news about what the Bureau of Protection is doing to protect consumers. Thanks very much for your attention, and be well and be safe.
Good morning, everybody. This is Susan Brown. I'm the administrator of the Division of Energy, Housing, and Community Resources at the Department of Administration. Our division is responsible for a number of energy and housing programs, as well as economic development programs, and all have the commonality of serving low to moderate income households. And if you want to go to the next slide. Housing is one of the largest expenses that many of our households have. And we know that a number of renters in Wisconsin are forced to make some tough decisions. And in many cases, they live only one, unexpected bill away from a crisis. And that was before COVID. And, now that COVID has become a part of our reality, it's even more difficult. Governor Evers had established a moratorium on evictions under Executive Order 15 that expired on May 26th. And in response to the need that's been expressed for assistance with rent, the Wisconsin Rental Assistance Program will be available beginning on June 8th, and it will be available to help assist renters from becoming evicted because they've had a loss of income pursuant to the COVID-19 emergency. RAP will be available statewide to renters. Next slide. So what is RAP and who is eligible? The eligibility for the RAP program will generally follow the guidelines that are set forth in the Wisconsin Home Energy Assistance Program. And very high level, that means that an applicant needs to be a Wisconsin resident. They need to have a current lease for housing in Wisconsin, or if they are moving into a new dwelling, there needs to be some kind of an agreement that upon payment of a security deposit and maybe some rent that they will be living in a new unit. The household will only be eligible one time for a benefit through this program. We don't want to be duplicating other assistance that's available to individuals. So if a household is receiving some type of public rental assistance benefits elsewhere, they would not be eligible for this program. And the household needs to, in some way, provide us documentation that they've lost a job or they've had a reduction in their hours, or that their circumstances that they find themselves in are a direct result of the COVID-19 emergency. The income eligibility limit for households and applicants is 80% of the county median income, and we look at the income of the applicant in the month prior to the date that they come in and apply. And then residents of public housing, such as Section 8, are not eligible for this program because there are other resources that will be available for those residents. And we are trying, again, not to duplicate other benefits that are available. Next slide. So a couple of high-level details. And I mention these because these questions have come up frequently for us. And the question we get most frequently is whether or not unemployment benefits count towards income. The answer is yes. If someone has received their unemployment benefits, that is considered in the calculation of their income. So it is not an ignored income source. We will give preference to households at or below the 60% of the county median income. But again, 80% is the eligibility limit, and we are running this program on a first come, first served basis. And then the program will expire either when the funding is exhausted or as of December 31st of this year. Next slide. So our eligible costs include rent and security deposits. There is a total cash benefit for the rent and the security deposit combination of $3,000 per applicant over a 3-month period. So for example, if someone comes in today and they need assistance with their rent, we can provide up to $1,000. If they continue to need assistance in the next month, they can request that assistance again. And the reason for that is to stretch these benefits as far as we can. For example, let's say somebody comes in and applies for assistance and they have not received their unemployment benefit yet. They probably are eligible if they don't have another source of income. Perhaps the next month, they will receive their unemployment benefits, and that may provide them with enough resources to pay their bills and pay their rent. So that's the reason for rechecking on a 3-month basis. We will make the payments directly to the landlord, and the landlord will need to provide us with information on where those payments should be made. There will be a form, and we will get to that as we go further, that the landlord will complete, and then we will be able to know where to direct the payments. Payments are generated automatically, and they are generated at the state level centrally out of a computerized database. So in that manner, we can expedite payments to the landlords and help the clients quickly. And then we could actually get payments out as quickly as 10 days after an applicant comes in for assistance. So one of the things that the community action agencies will be doing is working with clients and working with landlords in the event that someone is facing eviction to, if someone's eligible, to let the tenant and the landlord know. So perhaps that can be one of the items that could be used in negotiating what's needed for the tenant to remain in the housing. Next slide. Governor Evers allocated $25 million for this program, and the funding comes from the CARES Act money that came to the state. As I mentioned earlier, our division is contracting with community action agencies across the state, as well as with the Wisconsin Community Action Association for assistance with oversight of the agencies that are administering the program. Many CAP agencies, if not all of them, operate other housing and energy programs, and as was said earlier, they have other resources available often that they can help individuals with. So in addition to this base benefit, they'll also be providing things like housing counseling and budget counseling, and trying to get the applicants on a path to be able to be self-sufficient going forward. With that, we can go to the next slide. Any questions, or are we taking those later?
We'll go ahead and take questions at the end. So now
Okay.
Bonnie Juanita can present, and then we will do the Q&A session. Thanks.
Hi, welcome everyone. I am Bonnie Robertson. I am a Senior Housing Management Officer for Wisconsin Housing and Economic Development Authority. You've probably heard it referred to as WHEDA quite often. I am here to talk about the multifamily assisted housing and the CARES Act and what that meant to everybody. The CARES Act was put into place March 27th of 2020, and that stands for the Coronavirus Aid, Relief, and Economic Security Act. that act was put in and at the federal level. The main things from this, next slide, please. The main things from this is that it was applicable to all multifamily assisted properties, including both FHA insured properties and non-insured. It includes properties with a federally backed loan, and it includes properties that participate in the covered housing programs as defined in the Violence Against Women's Act. That would be pretty much anything with federal funding. Different ones that are included are all project-based Section 8 properties. WIDA is the contract administrator for all of those in the state of Wisconsin. And all the programs covered under the HUD 4350.3 handbook. We could go to the next slide, please. It also covers all the low-income housing tax credit properties in the state of Wisconsin. WIDA is the allocator of the tax credits for Wisconsin, and we are also the monitoring agency. It also includes all the rural properties in the state of Wisconsin and the Housing Choice Voucher Program. So anyone that has a voucher is also covered under this program. Next slide, please. In the CARES Act, there was a moratorium put on both evictions and charging fees related to non-payment of rent. This, as I said earlier, this moratorium on the federal level on these programs goes until July 25th of 2020. So the owners and agents cannot evict anyone for non-payment of rent during this period and cannot charge late fees. They still could process evictions that were related to violence, anything with the Violence Against Women's Act, or evictions that were in process. And as you heard earlier, they had already had the service done. Tenants under these programs, under HUD, can get any COVID-related questions answered in the brochure that HUD put out. I listed the website there, and it does give a lot of information about all the HUD properties. Another thing in the CARES Act is that any of these loans that go through forbearance, tenants will be protected even longer. If the property goes into forbearance, then they can't evict or charge late fees to the tenants during that time either. Okay, next slide, please. And as far as maintenance in properties at the time, currently maintenance is doing all emergency work orders, and they're kind of instructed to, ask a tenant if they have something that needs to be fixed, if it's safe to enter their unit. Obviously, because of the HIPAA laws, a tenant does not have to tell them that they have COVID-19, but everybody's hoping if they do, that they will let them know. Non-essential repairs are going to be made just as a unit-by-unit basis, and if the maintenance feels safe, they're going in and doing those. We're instructing them too that if they don't feel safe, they should contact the CDC and find out, what they should do. Okay. And with that, I guess we can take any questions.
Okay. Thanks very much to everyone. And let me just forward slide. Okay. We do have a few questions that have come in from the audience, and I was just kind of flipping through those real fast. Thanks very much to all the presenters. And I'm going to direct these questions to a particular person, but then anyone else who wants to jump in after that, please feel free to do so. So first off, we have a question that is actually, I'm going to direct to Jessica because this is pertaining to some screening questions. So what screening questions should we, meaning practitioners or people who are actually just working on their own issues, what should they ask before referring to legal action? Okay, so this would be practitioners working with clients. So what And I totally understand this question too, coming from a background in housing counseling. So this person is really wanting to know, at what point should a person be referred to legal action for their issue? Are there some screening questions that you would advise, Jessica?
Sure. Thanks so much. I would say, so Legal Action Wisconsin is a nonprofit law firm serving the southern 39 counties of the state of Wisconsin. With some exceptions, we also serve up north as well. But we serve people living, generally speaking, serve people living at or below 200% of the poverty level, which is kind of complicated for someone outside because we are allowed to or required to count certain household members, but not others, depending upon their legal relationship to support one another. So our financial eligibility may be different from other programs. It's very hard to say because we do have multiple funding sources. What I would say is if a household has less than $5,000 in the bank, cash money on hand, and has had an income interruption, there's a good chance they're going to be financially eligible for our services. We are a law firm. We also do screen for conflicts of interest, and that's something nobody but us can know. So if somebody is economically challenged during these times and they have legal questions, that's a great referral to make to us. I think that the best specific advice we can give is when they have a written notice in hand or written pleadings in hand. But some people want legal advice about how to prevent getting either of those, and we also offer that kind of advice. So I hope that's helpful and addresses the questions about how to screen for referral. Mm-hmm. Basically, people who are financially challenged and have a particular legal question. We don't help with. At this point, we never have money to give out. So if what the person is looking for is cash money, like we would be a bad referral. But if what they want to know is, should I have been denied for this public assistance program, we do that kind of stuff all the time.
Okay. I think that was a good answer. We'll leave it at that. And if there are some things that you might want to add later, Jessica, or if we happen to have other people have more things to add, we can always do a follow-up, perhaps email or the person who asked that can email me, and I can try to provide some additional information. Okay, so another question that was asked pretty early on in the webinar, so this is probably also to you, Jessica, which I'm just going to, given that we have so much time remaining, I'm going to go through all the questions, hopefully, and if any of the presenters can't answer at this point, or would like to kind of defer for a live answer, they can say that. But I am going to just go ahead and kind of run through all the questions, seeing as how we allowed a lot of time for Q&A today. So this particular question actually might even be more relevant for some of our other presenters. But the question is, how will these various services, and I'm assuming they're also talking about some of these emergency programs, apply to adults without a Social Security number? So specifically, people living in Wisconsin who maybe are not documented. And so maybe I'll start with Susan Brown if you have an answer, but then someone else feel free to chime in if you think you can add to that.
I can address the eligibility for the WRAP program in terms of Social Security numbers. The guidelines that we're using for this program follow guidelines that we use for other assistance programs, and a household must have at least one member who has a valid Social Security number. So that could be a child, but somebody in the household has to have a valid Social Security number.
Okay, excellent. Anyone else have anything to add? Okay, moving on then. This question is, the person is wondering if individuals trying to secure a residence from a DOC facility or apartment and only work part-time or have been underemployed since release from jail or prison would qualify. And I think that this probably was pertaining to that RAP program. So I'm assuming maybe one of the presenters has some clarity, but Susan, is that something you could answer? Or maybe Laura.
Right. So in terms of the RAP program, I think as long as someone, has a situation where they are potentially being evicted, they would qualify, but I think I need a little more information or a little more clarity on that question, so I don't mislead anyone.
Yeah, and unfortunately, I don't. It looks like the person who asked this question has actually left, I believe. So we'll move on from that, but maybe we can follow up offline.
Okay.
Let's see. Are RAP benefits only for tenants who have a written lease? What if it's not written? So this kind of goes back to some of what Jessica had mentioned about that, tenant, how broad that can be. So, Susan, if you want to say something about that, but then someone else jump in too. I'm going in order, so these are all kind of getting pushed to you right now, Susan. Sorry about that.
That's okay. No, that's okay. So we have a form that applicants can use. It may not be a formal lease, but basically it's some kind of an attestation that someone is, in a situation where they are paying rent. And if there's not a formal lease, we do have another form that can be completed to prove that.
Okay. Okay, so I guess we did have a question that was, I guess some people are wanting some more specific information about resources for home ownership, so kind of getting into a different area. So we do not have a webinar at this point planned that will specifically get at that population. This person was talking about mortgage and or escrow payments, and so we don't have that on the docket right now, but I do know that there are resources, and at the end of the webinar, I will provide a resource page where UW Extension has brought together a lot of different resources, and I will refer everyone to that after as well.
This is Jessica. Can I just jump in on that?
Oh, sure. Yeah, absolutely.
Okay. There have been a number of really meaty webinars presented by NCLC, which is the National Consumer Law Center, about CARES Act, how the CARES Act regulates and provides options for homeowners who have some of these federally insured mortgages through HUD or the VA or USDA. So that would be a resource that I would just say, homeowners, you need to know what kind of mortgage you have to know what your options are under the CARES Act and the particular COVID relief provisions that are out there. But the NCLC would be a good place for homeowners to look. Those webinars, I believe, have all been recorded, and there are PowerPoint slides that go through it in pretty good detail on what your options may be.
Great, that's helpful, and I, if at all possible, I think we could make a link to that as well following. So I've made a note in my Q&A document right here. Let's see, moving on. How fast will the landlord payouts arrive from RAP after the renter has applied?
So
sure. Yeah.
So it's if the applicant has brought all of the information that they need to determine their eligibility within 2 weeks. But that, again, I want to be cautious that people understand that that is if all of the information is provided.
Okay. Thank you. Anybody else have anything to add? Okay. So Jessica, I have a request that you kind of do a recap of what evictions can currently be served. March 27 and prior filed evictions can't go forward, question. Only evictions filed in court beginning May 27th can begin. So it looks like this person is looking for some clarity and perhaps a short recap of what evictions can currently be served.
So your mileage may vary, and what I would say is if you have a specific fact pattern, your best bet is to get specific legal advice. However, sort of generally speaking, some evictions were allowed to proceed even during the moratorium, right? So if you have the kind of eviction that was based on a health or safety emergency, those were never stopped. If what you have is a kind of eviction where the problem is rent has not been paid, those are the ones that were subject to a moratorium. And depending on the funding for the building that's being rented out, may still be under a moratorium, a federally imposed moratorium. So you have to know the specifics of the property, how the mortgage on the underlying property was financed, and also what the basis of the eviction is to know whether or not it was proper for that to have been filed or to proceed either prior to the moratorium, during the moratorium, or even now after the state moratorium expired, but there's still a federal moratorium for certain kinds of properties. So that's kind of a lawyer answer, but the answer really is it depends.
Okay. No, I think that's helpful. This one, I think we kind of already covered this. I think Susan had already kind of said something about it, but what about for the WRAP program, specifically expired leases? Are those eligible to apply?
That's a very good question. I think that what we would need is, again, some kind of attestation that a person is living in a dwelling with a responsibility to, pay that rent, who is facing eviction. I think as Jessica mentioned earlier, there's different types of relationships that can exist. There can be formal leases or informal leases. So that's a question that we hadn't considered, but I think that our answer would be that there would need to be something provided in writing that would identify or testify to the fact that there's a rent responsibility.
Okay, thank you. And this next question is kind of more, well, it's a great question actually, kind of around the process. So the question is, will WRAP send a letter to the tenant and landlord after an application is complete to say that the funds will be sent to the landlord within a few weeks? The reason being that this could be really helpful to show landlords that this is in the process and they have something to kind of look toward, so they don't move forward with an eviction. So will there be some kind of documentation or something earlier in the process than that could help,
There will be a letter generated to the applicant upon completion of their application, indicating that they are eligible and will be receiving a payment. the landlord would just receive the check. But I'm assuming that there could be something negotiated with the local community action agency. So I think the community action agencies, as just, by practice, would potentially be in contact with the landlord and letting them know that.
Okay, thank you. And just to let people know, I've received a couple questions about whether this will be recorded and whether this will be available. And yes, it will. It's being recorded, and I will be posting it on our website, cfs.wisc.edu. But you will also all be receiving a copy of that recording with in an email tomorrow. It's kind of like a follow-up to the webinar that's auto-generated when you registered. And then another question, this is along the same lines. This is a question that was submitted by the same person as earlier, who was talking about people transitioning out of prison, and she got kicked off because of internet, and so she's back on now and had another question. And the question is, in reference to the RAP program, individuals that are moving out of a state-run facility that did not have to pay rent but are underemployed and are looking for housing, would they qualify for RAP? So yeah, a little.
Okay, that's a slightly different twist. I think I need to get back to that question. I don't have an answer for that right now.
Fair enough. And then again, another question on this program. Are the RAP resources also available for commercial properties? And if so, what documentation is needed?
Can you explain to me what the person means by commercial properties?
So I don't have, well, unless they quickly ask, but I'm assuming that they're talking about a property that's used for retail or commercial purposes where they are unable, that they're renting for that purpose, and whether the RAP program is available to them.
Sure. With that explanation, I think the answer is no. This is designed for individuals, not businesses.
Okay. And I don't know, that person might have been thinking about more of kind of I don't know, it could be that a residence might also be serving as she said, if a business is leasing space for programs. I'm not sure.
No.
Okay.
Right. Based on that, I think not.
Okay. So that is, I'm going to just kind of do the pause for about 10 seconds to see if any more questions kind of filter in. But I think that we've reached the end of our questions that all were kind of coming in throughout the webinar and then here at the end. And I don't see any more making their way to my Q&A box. So I'm going to go ahead and forward to the next slide. Thanks so much to the presenters for taking all those questions too. I know that was, they just were coming at you fast, Susan, especially. As I mentioned before, I wanted to reference this financial resources page that has been put together by UW-Madison Division of Extension. Peggy Olive, who is a CFS colleague of mine, has put a lot of work, as well as her colleagues have done a lot of work to keep this website updated on a daily basis. And so if there are questions that you have that are outside of kind of this or part of this tenant and landlord question. But if there are other areas that you're interested, this is a very comprehensive website that draws in all sorts of resources. And as I mentioned, this was recorded, and it will be posted on our website, and you will all receive a recording following the webinar, probably tomorrow. It typically is the day after the webinar, but it's Saturday, so I'm not sure how my program actually deals with a non-business day. But I also wanted to remind everyone that we do have another webinar coming up next week, Tuesday, June 2nd. It will be from 10 to 11:30 a.m., similar to the time frame that we held today. And this webinar will be, it's titled The COVID-19 Crisis and Student Loans, a webinar event for borrowers and practitioners. So this webinar will focus on student loan debt and different programs that have sought to help borrowers in that situation. And with that, I would just like to say thanks very much to our presenters for taking the time out of your busy schedules to share this very timely and valuable information. As Laura mentioned, this webinar came together very quickly, just within the last week, and that was in order to bring this urgent information to the public. So I would like to acknowledge all of the presenters and to highlight Laura Sutherland and who did much of the planning. And so thanks very much for prioritizing this webinar. And thanks very much to our audience members. Please stay healthy, stay safe, and be well. Thanks a lot.